look, I've been practicing for 11 years. Much of my work has been focused on harassment and assault, sexual harassment, and sexual assault claims. And so I have dealt with the worst of the worst. I've dealt with actual victims. I have both prosecuted and defended allegations of sexual harassment. I've cross-examined purported victims on the stand. I just know what that looks like. And so when I see these allegations of Blake Lively, where she's inviting people in her trailer, and her version of sexual harassment is, you looked me in the eye while I was pumping. You're the one that offered the invitation, dipshit. And so what are you doing? And so that and all the others, the rest of it, right?
Right.
And ultimately, I said way back in January that what this case is going to be known for is not the sexual harassment. It's going to be about how PR is conducted in America going forward. And the textbooks, when in law schools, that's what they're going to teach. It's not going to be about these SH claims. And so for this case, I have been cognizant of the fact that I believe that Blake Lively has weaponized sexual harassment to get the upper hand in litigation and chill the causes of action that Baldoni could bring against her. He did it anyway, ended up getting dismissed with prejudice. We could talk about that later. But she did that, and she did it intentionally. And it's an example of how this Me Too movement, because that's where 47.1 comes from. In California, they literally brought and wrote that motion based on the Me Too movement and a lot of their themes. And look, they meant well.
You're absolutely right.
But where you could exploit it is Blake Lively, who's way more powerful than Justin Baldoni. She has this whole network of people in support. You know, I know the Sarah was in the whole thing, but whatever. Still, she's taking advantage of it and basically saying, you're going to bring the defamation suit. You better win. Otherwise, treble damages. And then Judge Lyman dismisses it with prejudice. So she's already subjected to all of that. Strategically in that case, now that that's happened, I really feel like it's a good thing for Baldoni, because it takes away the distraction of this complaint, and it caps damages for 47.1 at whatever it was prior to, I guess, June 9th, I think is when they dismissed it. So he may be out 46 million times 3, so 12 to 18 million in attorney fees and costs. If he goes to trial and he proves her to be a liar and that her sexual harassment suit was not brought in good faith, and he's awarded attorney fees and costs, that might be in excess of $100 million. And so the monetary aspect of this case is not over by a long shot.
So you're saying it sounds like that even though he's now in a strictly defensive position, that if he wins that game, then that can still hurt Blake Lively.
100%. And so now that we're not distracted and trying to like connect these dots and conspiracy about how Blake Lively was trying to take over the film and like turn it into a franchise, we don't got to worry about all that. Let's just focus on how ridiculous her claims are, and proceed that way. It's much easier.
I like that. And that's something that I think a number of us need to hear. I'm going to be honest with you. I was demoralized, not like totally shredded up. I'm never going to do this again. Like I've been doing these things. I've been covering these cases for 5 years. And like I said, I've covered a lot of other cases. And so I expected this. I knew it was coming. It snuck up on me only in the timing that I thought it was, we had a little more time, but I knew it was coming, but it was what demoralized me. And again, I'm not trying to harp too hard on Brian Friedman or on Justin's PR team here, because I know that they pulled off a miracle in getting him out of the pit that he was in when Blake Lively had just destroyed his reputation early on, you know. And so I want to give them all credit for that, and not saying I would do any better necessarily, but I was upset about the fact that was not teed up PR wise, we were not not me, but in general, a lot of people, I think, who really thought Justin had much more of a shot at this and were expecting it to go to a trial. I think a lot of people were caught off guard. And then when that happened, then Friedman issued a statement, right? Or he went on Megyn Kelly or something, and he said that, well, basically we're doubling down and we still have these other claims and we're going to make, and we're still going to trial and all that. And then to flip from that a week later to this very quiet withdrawal with, again, at that point, no explanation. To me, it just felt like, man, you really didn't stick the landing on this. So it's good to hear. It's good to hear, though, what you're saying, and to keep this in mind, that there's still a huge trial that's coming up.
Yeah, no, the optics are bad. And I'm not going to, look, Friedman's made some mistakes. He's probably one of the best attorneys in the world, but he did make some mistakes. His cross complaint was not artfully pled, for sure.
You thought so?
Yeah. But I thought he was going to have an opportunity to fix it, and he didn't get a chance. And so, but if you just think back to when you
how bad? I'm sorry, but I'm just curious.
Sure.
How inadequate was that? Honestly speaking, that cross complaint that Friedman.
It was pretty bad because I mean, all of the 12b6. The 12b6 motion pointing out all the deficiencies in the complaint were true. They did not give an offer of proof as to any defamatory statements on the part of Lively. They was all protected in the CRD. They did not lay it out bullet point by bullet point what specifically the conspiracy was supposed to be. And then the judge basically said that, look, he's saying Ryan Reynolds in the sexual predator language, fine, but what if he just believed his wife? And so, therefore, I find your argument unpersuasive. I'm going to grant the 12b6, and with prejudice, I don't think he could even fix it with an amended complaint, which I thought was a bit much, but that's where he went. And so, whatever to that.
Could I? Would you go so far as to say, since I'm prompting you to, would you go so far as to say that if that document, that filing by Friedman had been better written, that they could have gotten this maybe across the line? Or do you think this was always going to get dismissed by Judge Lyman?
No, I did not think it was going to get dismissed. What I thought was going to happen was that, because look, I mean, right now I've had the benefit of, we're now middle of July. This was dismissed back in June. They wrote the amended complaint back in, was it February or March? We know a lot more about the case. And so, but what I thought was going to happen was discovery was going to allow them to fill in the gaps. And look, I know what's missing, and this is what we're looking for. This is where we're going to find it. And, at least stave off a decision on 12b6 until the completion of discovery. Like, it would have made a lot of sense to delay ruling on 12b6 until, say, the end of August or something.
But he did it. And do you think that the judge didn't, because he did feel like this filing by Friedman was so inartful or was so inadequate? Or do you think that he was just probably going to do that anyway? I guess I'm trying to say, how damaging was it? Do you think that Friedman's people or his people did not do a bang up job on that document?
Well, if what Lyman said was this, it's like, I know what your theory is generally, but if I have to go look through your Exhibit A to find that you pled the theory, I'm not doing all of that. You have to lay this out for me like I'm 5. And they didn't do that. And so, it was problematic. But again, if I analyze that 99 out of 100 times, I feel like that's at least, I'll grant the motion, but you got 30 days to amend.
I see. So you feel like the judge was being a bit extreme.
Oh, yeah. No, I think that he treated it like it was a motion for summary judgment. And insofar as it's supposed to be the fact that when you have that motion, all they have to do is plead the facts. Just plead their case. You're not supposed to evaluate the evidence. Like in a motion for summary judgment, it's like, this is all the evidence they have. And if this is all they have, there's no jury that's going to reasonably find in their favor. And so he was evaluating it as if he was looking at the evidence like, yeah, I see what you said, but that doesn't make sense because Lively's married to Reynolds. And so therefore I call bullshit on that. You're not even going to be able to fix that on amendment. So I'm just going to deny it with prejudice. That was a bit much. I thought that was possibly left him subject to appellate review. They didn't appeal on the basis of law. And so they could potentially still appeal if they lose the trial. I just don't think that they're gonna. Look at it this way. Way back in January or February or whenever it was that Exhibit A came out, I don't know if you, but everybody was so focused on how ridiculous the sexual harassment claims were. And they're like, Lively has no case here. Like Baldoni and Friedman is going to steamroll her, right? That's what everybody was focused on. But then you saw this cross complaint come in and everybody's trying to make that work in their own minds, and internet sleuths and Reddit pages are trying to make that work out. But it was hard because the cross complaint was convoluted. If we just focus on how ridiculous the claims were, this is a much easier case to evaluate, and it's not good for Lively. So I completely understand, myself included, when I saw I think I was just so distracted when Judge Friedman dismissed with prejudice. Like it took me a good week to kind of like.
Is that kind of unusual? Like, I guess was he? was he kind of laying it on a bit thick? I know some people say, oh, he's corrupt, or oh, it was this
Yeah.
was really inappropriate, but you do feel like he was leaning a bit heavy toward Lively's side.
I do.
Yeah.
It honestly, it caused me to look at him a little bit sideways in a way that I hadn't before.
So you mentioned at the beginning about the fact that what started this whole thing, really what set this whole thing in motion, were the illegally obtained communications. And just for people who don't know, very quickly, you want to give people a brief rundown of that.
Yeah. So here's what happened. I think it was back in August of 24. Jen Abel is cornered by her employer in her office, like in the whatever high rise they were in, by like a couple of security guards. And then she was basically shaken down, forced to give up her phone. On her phone was a lot of business stuff, right? Because it was a work issued phone, but she also had a lot of avenues to her personal data. Like, so they had work stuff, but if she ever signed into like maybe her Apple Cloud or whatever, then they gained access through that in a way that they shouldn't have, that is potentially criminal in nature. At the very least, a breach of fiduciary duty. There's like 8 different causes of action that I laid out like a few months ago about what it could possibly be, but who's going to be prosecuted and for what, I don't know. The point is that they illegally obtained evidence, and those communications, if they were based on her personal communications, were illegally obtained, and they tipped them off that Brian Friedman was getting ready to file a civil extortion lawsuit against Lively and that whole group. And in response to that, they filed a CRD complaint. But then they reference this weird subpoena that nobody knew what it was at the time.
The only thing I want to add to that is just to emphasize that then once they meaning Stephanie Jones, Jennifer Abel's employer, right, who had taken her phone from her, once she obtained this information, then apparently we surmise that she must have transmitted it, given it to Blake Lively and to Blake Lively's people, because that was the information you mentioned. That was the information that we see show up in the CRD complaint. So I just want people to understand that there are sort of double violations here going on. You've got on the one hand the access to Jennifer Abel's stuff by Stephanie Jones. You know, her employer takes this phone from her, but also then uses it to dig in and access stuff that she shouldn't be privy to, right? And then also transmitting the information obtained through that or text or whatever to Blake Lively's people, so that then they could use that in their lawsuit, right? And so that's what you think, right? Isn't that kind of what happened?
Well, that's not just what I think. That's what Friedman thinks. So that's what he literally wrote in his discovery. So they took that, and now they've based this lawsuit on illegally obtained evidence. So they got to fix it somehow.
Right.
So they launder the evidence. They create this bullshit lawsuit. I don't know if I could curse on the show.
Oh, you can. I love that too. I love the term though that you use, launder the evidence. Exactly.
That's exactly what they did. So they have this illegal evidence. They filed this Van Sham lawsuit. They allege a breach of contract. This is how ridiculous this is. If you have a contract with somebody, it's a promise between me and somebody else, like me and you. We've contracted for something.
Right.
I'm going to give you something. You're going to do something for me, and that's going to form the basis of a contract, whatever. So they're alleging a breach of contract, and they don't name any defendants, those 0 through 10. That's ridiculous.
Because there aren't any, right? They're not wanting to be specific. They're just wanting to basically cast a wide net to give them an excuse or a reason, or to say, oh, look, we did, this is how we got this information, right?
But here it's even worse than that, because you're claiming there's a contract and you made a contract with somebody. I don't think of any contract that you've ever made with anybody that you didn't know who you made a contract with. You're going to know the person who that was, who the business was, whatever. Right? That's what they're claiming. Those 0 through 10. So then they have subpoena power now in New York, and they issue this subpoena whom they have no, they don't have to notify anybody. Nobody has the opportunity to object. They give it to Abel. I don't know if she hands it to her attorneys. She must not have, because it was such a quashable subpoena, but she just complies and gives them all their information.
Scared or something.
Right. And so because she's not notified anybody, now they have this evidence and they've obtained it legally. What was previously illegally obtained evidence has now been given color of law. And now it's been cleaned up, and now they filed the lawsuit. So here's how huge that is. the whole discovery motions that were recently ruled upon by Judge Lyman says, look, they say that they have this theory that you use this to illegally clean up this evidence or whatever. That's relevant to me. I'm going to allow it. That means that Friedman is gearing up eventually, like in a month or two, maybe sooner, for a motion to possibly make all of those communications inadmissible because of how they were obtained, based on abusive process. And if he does that and they are made inadmissible, that's going to gut her entire lawsuit, but for the sexual harassment claims. And now the case is no longer even about a smear campaign. It's just about the SH claims. And so if the judge takes that motion and denies it and allows it to happen, that's going to set such a wild precedent in the Second Circuit, because it means that you could just look, bullshit lawsuits are apparently allowed. Just file, make up a lawsuit, name whoever does, issue a subpoena, and attorneys and people know how to use it will have unfettered access to subpoena power, whoever they want.
That's true. I never thought about that. And not only unfettered access to subpoena power, they were able to get their access to this without these people being notified, apparently, because there were no specific people, right? Like they weren't notified.
Right.
So again, for people to understand, and this was the thing that I filed that bar association complaint about. I never heard back from them, by the way. So I'm following up on that. That's going to be an episode of my podcast this week. But for people to understand, basically, again, what we're saying here is that they got information from this woman, from Abel. They got it illegally. Their employer got it, and they transmitted it to Blake Lively, which she was not supposed to do. This is confidential information. Jennifer Abel did not give her employer, Stephanie Jones, permission to give Blake Lively all of this information, text off her phone, pass, all these things, right? So then, then they want to use this. Blake Lively's team wants to use this in her CRD complaint, but she knows that she can't admit where she's gotten it. It's illegal. So that's they get it from this sham lawsuit. This basically this shell company, this Van Zandt company was this Blake Lively and Ryan Reynolds shell company. They had never used it before, right? Except once to order some personal furniture, right?
Yep, that was it. That was it.
So this is a completely frivolous, fake lawsuit, and they were using it strategically. And here's the thing. Don't you think, Omar, that they thought no one would notice this? This is the kind of stuff that you do that you don't think is ever going to come to light as a lawyer, right?
Yeah. Well, I mean, they said, look, this is not illegal. It's technically allowed. This happens all the time. And then Friedman's lawyer is like, no, this doesn't happen all the time. Because, well, here's the other thing, too. Like, not only is this evidence going to be inadmissible, but it could possibly give rise to an independent cause of action.
What does that mean?
Abusive process, where they could be liable for damages stemming from this. So it could end up in, I don't know if it's going to be in this case, Lively v. Baldoni. It might be in a subsequent case, but it will give rise to an independent cause of action where they'll be liable for sanctions and damages stemming from their abuse of process. And so it's just another remedy that is available for Baldoni with a favorable ruling.